Good morning. In our first video, we took a look at how the federal court system was structured. In this particular video, though, I want to take a look at this question. The federal judiciary was designed to be an independent branch, but its rulings are as controversial as the actions of the other branches, or even more so in some areas. Why is that? Before we delve into that, I want to take a look at this particular Supreme Court case, Marbury versus Madison. Now, Hamilton may have argued that the federal judiciary was the weakest branch. However, this particular court case did a lot to challenge that particular claim. After all, in Marbury versus Madison, the court under John Marshall, a Federalist who supported strong national authority, argued that the U.S. Supreme Court has the authority to determine any act of Congress or the president unconstitutional. Now, judicial review even goes further than that, especially when it's backed up by Article 3 of the Constitution, indicating that the U.S. Supreme Court is the highest court of the land. What that ultimately means, folks, is that state legislators are elected popular by the people. Okay, governors are elected by the people. The president is elected, granted through the Electoral College, but still with the popular vote in mind, or at least a factor in that. The courts, the U.S. Supreme Court, a body of 9 unelected individuals, can tell all of those elected officials across the United States, nope, that's unconstitutional. You can't do that anymore. That is a huge amount of power that the courts have over our daily lives, folks. And I want you to think about that for a moment, because those powers can extend in a variety of different aspects of our lives, be it workplace rights for gay or transgender people, Second Amendment matters here, new abortion restrictions, rollback of deportation protections for undocumented immigrants. This is ultimately why these interest groups play such a large part when new nominees come forward, and they play a large part trying to tell those senators, hey, look, you should support these U.S. Supreme Court justice nominees, or no, absolutely not, do not support them. And if they don't get their say there, what they'll do instead is that they'll issue what are called amicus curiae briefs. Ultimately, what that grants them the ability to do is if someone sues a state for violating their right to use a neutral bathroom, someone that is not sex specific, okay? GLSEN here might ultimately issue that amicus curiae brief as what's called a friend of the court. What that means is they're saying, we support you fully here. Planned Parenthood will do the same when any challenges come to abortion laws, and the ACLU will ultimately do that with something like these deportation of undocumented immigrants. But what guides a lot of those presidents from coming in are the specific guidance of the presidents who nominated them. So what are presidents looking at in nominating the judges that they select? Well, they're looking at the experience, obviously, their party affiliation. Now, granted, remember, federal judges are meant to be independent, which means that they have no stated party, but they vote a particular way, and the presidents are going to want to look at that. They also lean a particular way, conservative or liberal. And again, that's not something that's stated openly or widely there, but the presidents are going to pay attention to the types of rulings that they've made, the statements that they make, the views that they have made in the past that guide them towards what ideology they belong to. Finally, they're going to look at race and gender, as well as senatorial courtesy. You can see here that different parties value different aspects of these selection criteria. But what's that look like in application? Now, granted, you see how some presidents value gender or race differently there. We can still see very little diversity on the court itself, with virtually all coming from Harvard or Yale. When I had the opportunity to meet Supreme Court Justice Sotomayor, she brought up another problem with diversity, that none of the Supreme Court justices have experience as trial attorneys or trial judges. What that means is they're going to have very little understanding of what kind of impact their decisions have at the ground level. And that's a pretty big criticism of the courts themselves. Hamilton's arguments, though, of the need for an independent court are pretty darn important, though. We see what heavy role that the presidents can play in selecting new nominees. Sometimes they can ultimately try to go even further than what the other branches feel is appropriate. I'll clarify. During Roosevelt's New Deal and trying to address the problems of the Great Depression, his feeling was, look, Congress is supporting these New Deal bills um, with very strong majorities here. I'm obviously behind them, but you fuddy-duds on the U.S. Supreme Court are finding these particular bills unconstitutional, and this is ridiculous. So Congress, I need you to do me a favor. I want 6 new Supreme Court justices on the court, and Congress, you have the authority to do that. Well, you can imagine right here is where Congress, as well as the American people, said, whoa, slow down. That would completely topple our system of checks and balances. Of course, Roosevelt is thinking to pack that court with 6 new judges sympathetic to the New Deal. And this would ultimately sacrifice our system of checks and balances. And the reason for those concerns, folks, and the reason why it's so important that we do have questions and concerns regarding who the presidents nominate is that the impacts of their decisions can last decades. So the Warren Court here did more to expand criminal rights, did more to expand free speech rights, and established the principle of the right to privacy. All of that happened during the Warren Court. Many of us would consider these very strong liberal leanings here of this court system. This shifted some under the Burger Court. Warren Burger was nominated by Nixon. And he did make a few more conservative decisions, like upholding the death penalty, like restricting affirmative action programs from engaging in quotas. But he's also the one who presided over the Roe v. Wade decision, as well as U.S. v. Nixon challenging executive authority. The shift further right became quite a bit more so under the Rehnquist Court. Rehnquist died in 2005 and was replaced by John Roberts, who holds many of the same views as Rehnquist. And I think Rehnquist makes those views quite plain here when he states the wall of separation between church and state is a metaphor based on bad history, a metaphor which is provide useless as a guide to judging. It should be frankly and explicitly abandoned. What I think is so important about that specific statement, folks, is that earlier courts had ruled prayer in public schools unconstitutional. Earlier courts had ultimately affirmed the wall of separation between church and state, and even allowed people the right to not to pledge allegiance to the flag. I question whether or not Rehnquist would make similar decisions. Whether or not you support those specific views is up to you. But this really did bring about a pretty big shift in some of those rulings. And that is ultimately why, folks, as you see the courts leaning a little bit further right or leaning a little bit further left, nominations have grown far more contentious. What I want you to pay attention to is these 2 headlines here. Nearly 6 in 10 current federal judges were appointed by Democratic presidents. Then it says here to the right, Trump has appointed more appeals court judges than any other recent president at the same point in his tenure. Why I think that's so important is that you see presidents trying to wield their influence over the courts through their nominations. And ultimately that swings them further to the left when Democratic presidents are making more of those nominations, or further to the right when more Republican presidents are making those nominations. And as those ideological leanings have grown more pronounced, people have grown more conservative or more liberal, that's made it a lot harder to nominate new justices to the U.S. Supreme Court. You can see that Brett Kavanaugh, the latest U.S. Supreme Court justice, barely was nominated by the U.S. Senate. They got 51 votes. That's it. And that's ultimately what they had to have. You can see 1 Republican voted against that. Again, this is where interest groups like the ACLU, like Planned Parenthood, like GLSEN likely played a large part against Brett Kavanaugh's nomination. They ultimately failed here, as you can see. But let's compare Kavanaugh's nomination to earlier nominations here. You can see Scalia, Kennedy, and Ginsburg here. Ginsburg is a strong liberal. Scalia and Kennedy were conservatives there. Both overwhelmingly voted there. Thomas's vote was pretty slim, but that's ultimately because of charges of sexual harassment allegations from Anita Hill. Overall, the trends were much, much higher, Democrats and Republicans. But as the population within the United States grows more and more polarized, so do those nominations. Hence, the nominations of those Supreme Court justices gets much tougher. This is the current U.S. Supreme Court. Justices Breyer, Sotomayor, Kagan, and Ginsburg are all considered part of the liberal wing of the court. Justices Gorsuch, Thomas, Kavanaugh, Roberts, and Alito are all considered part of the more conservative wing on the bench. And you can see that graphically demonstrated here. But is it fair to look at these ideological leanings of the court? After all, a number of people argue that the political leanings of the court don't matter. All that they're looking at is the law. Either the law is this or the law is that. And we can see in the statistics here, there might be merits to some of that argument. After all, the largest number of cases that are ruled by the U.S. Supreme Court are unanimously made. We can see 37% of their decisions are all made unanimously. And the 5-4 decisions are roughly 20% of the case. So almost double of the cases ruled are ruled unanimously. So should we pay as much attention to the ideological leanings of the court? Maybe, maybe not. Partly why there's a greater number of unanimous decisions is that judges tend to support a view, what's a philosophical principle or a legal principle called stare decisis. What that means, guys, is let the decision stand. This is ultimately why the vast majority of the cases are never heard by the U.S. Supreme Court. They simply say, hey, appeals court, you made that decision, we like it, let it stand. District court, let it stand. The main reason why they hold this view, guys, is that you do not want a legal system that is topsy-turvy, that is constantly changing, where a conservative appoints a justice and all of a sudden super conservative laws, and now a liberal president is now appointing judges, now all of a sudden they're all liberal laws. You would have a system of chaos without a greater focus on the consistency of laws, and that is assured through stare decisis. But views on what it means to follow stare decisis vary, and when it's okay to step away from that vary. And that's largely based upon two prominent views on the court today. One is called living constitutionalism, and the second is called originalism. You can see the philosophy of living constitutionalism exemplified by Justice Anthony Kennedy. Now, it's worth noting here that Justice Anthony Kennedy was considered a part of the conservative bloc on the court, a moderate part of the conservatives, but a conservative nonetheless. And he states here, they, meaning the LGBTQ community, ask for equal dignity in the eyes of the law. The Constitution grants them that right. That isn't something that an originalist would ultimately argue, and the reason for that is that nowhere in the Constitution does it state anything belonging, any rights, any liberties belonging to the LGBTQ community. Therefore, he's saying it's up to the states to make that decision. Whereas living constitutionalists argue that the Constitution is a living document with changing standards and values over time, and it's important for the courts to keep those standards and values in mind. After all, that was how the decision of Brown v. Board of Education was made. If they opted for stare decisis, they would have let Plessy versus Ferguson stand of keep them separate but equal. Now, don't go thinking that living constitutionalism is something that you're always going to get behind, or that it's some liberal view. The reason why I say that is that's also what allowed the case of Bush v. Gore that stopped the recount within Florida, and it also ultimately led to the decision of Citizens v. United that allowed unlimited expenditures from corporations during elections. But there's also originalism. So let's take a look at that. This is one of the prominent justices following an originalist stature. Scalia had a profound influence on two new justices on the court, and that is Gorsuch and Kavanaugh. Let's take a look at what originalism is largely based on. Scalia states here, the death penalty? Give me a break. It's easy. Abortion? Absolutely easy. Nobody ever thought that the Constitution prevented restrictions on abortion. Homosexual sodomy? Come on. For 200 years, it was criminal in every state. In other words, again, the originalists argue that if it is not explicitly stated within the Constitution, then the courts ultimately have to let the state laws stand, that it is up to the state laws and ultimately at that level for them to make those decisions. Now, whether or not you agree with Scalia or with Kennedy is completely up to you. But what I want you to see here is, yes, the goal is for the courts to remain as independent as possible. And with things like stare decisis, That largely does keep them focused on the consistency of those laws. But we can also see that there are a number of areas where justices step away from those specific areas. The question that I have for you is when should they and where shouldn't they? Should a philosophy like living constitutionalism guide them or originalism? Thanks for the time, guys, and have a great day.